right, I believe I'm online. Good afternoon, everyone, and thank you very much for joining me in this webinar. My name is Alia Makolo, and I am an International Arbitration Associate in Lexis Law Firm. Now, before we begin, and whilst we give a number of attendees the opportunity to log in, please allow me to wish everyone attending this webinar from the Republic of Turkey a happy National Sovereignty and Children's Day. So for those of you who are unaware of this meaning and significance, the Children's Day, in short, is one of the most important and unique national holidays celebrated throughout the Republic of Turkey. This is a day whereby we celebrate the history of the Republic of Turkey and the first gathering of the Grand National Assembly. Today is its 100th anniversary. Now, going back into our subject and assuming that everyone that is interested in the subject has logged in, so as you may see from the title of this webinar, which is the re-evaluation of arbitration and litigation proceedings within the scope of the COVID-19 crisis. The aim of this webinar is to provide the attendees with basic information through which they may fairly re-evaluate their positions on these two widely recognized procedures, so namely litigation and arbitration. And the reason for doing so is quite simple. When we are involved in a dispute, and as unpleasant as that may be, we need it to be resolved in the fastest, easiest, most cost-efficient way possible. However, as our circumstances are changing in an unprecedented manner, which I would assume most of you would agree, what we deemed as suitable for our circumstances may not be as suitable as we had previously thought when other external and internal factors are considered. So we thought, for this purpose, the novel coronavirus disease, the COVID-19 outbreak, and its following impacts were great examples. So this webinar shall consist of brief introductory information for the purposes of one, examining the core primary differences between arbitration and litigation, which obviously will allow you to decide what is beneficial depending on your own personal circumstances, but also the current ongoing effects of the COVID-19 outbreak on these adversarial proceedings and what this means for you. And before I begin, again, I would like to note, as the time allocated for this webinar is quite limited, the information provided here shall mostly include widely accepted principles and opinions in the field of commercial arbitration. Therefore, I urge every single one of you to examine the national laws that you must abide by before making a conclusive decision on the subject of this webinar. So going into litigation, and obviously, as I would assume most of you know what it means, but again, to define it, it may be defined as the default dispute resolution process administered and fulfilled by a national court of law. Now, looking into its characteristics, it is the traditional route, the primary route for dispute resolution. This is, of course, unless an additional step is taken by the parties of the dispute, or, of course, if the dispute could not be resolved by any other means, such as mediation or negotiation. It is administered by professional or lay judges who make decisions on cases on a daily basis. Again, every single matter concerning the litigation process is strictly bound by national rules and regulations of the respective country, more so in countries which have adopted the civil law system. And these matters include the way judges are selected or appointed, or the competence and authority of the courts. So these national rules and regulations lead to the fact that there are, one, clear and fair procedural rules that ensure the parties are able to put their cases properly, which means that they can present their cases in a proper manner. But also, two, there are balanced and transparent rules of evidence, which ensures that information relevant to the dispute is admissible. And again, it is a state-supported system, which basically means that it ensures reasonable access for potential litigants, but also supports the enforcement of national court judgments. And what I would like to say by legal advice access is that almost all lawyers are knowledgeable in the litigation process, may they be your internal counsel or external counsel. But obviously, looking into all of these, a question still stands. Is litigation still well suited for your dispute? And what I would urge every single one of you to do is to ask yourself a few questions. And I will start by saying, do you contract with many parties from all over the world? Are you or your business involved in transnational relations? The second would be, do you operate in a particular sector? And some examples could be energy, construction, infrastructure, banking, financial services, or technology. Another question is, of course, whether or not you encounter particular types of disputes or anticipate a dispute with a complex with a complex and technical nature, which may potentially require extensive expert evidence. This is quite important as, with respect to litigation, specialist courts required for the fair management and resolution of particularly complex and or technical disputes may not be available in some countries. Again, there is the interest that you must balance. What are the aims of your stakeholders or the management of the legal entity? Another very important question is, what is the desired speed of your proceedings? Do you need to resolve your dispute as soon as possible due to ongoing services, business operations, or relations? Again, with respect to litigation, attaining a finalized court judgment may take longer due to various reasons. These could include factors such as the judicial infrastructure of the country, the cultural approach of the judiciary, mandatory steps that must be complied with prior to commencing litigation, and the appeal process of the respective country. And to give you a few examples, the judiciary at certain times, including in the Republic of Turkey, cannot at times meet the demands of the parties due to the sheer volume of their cases. Whereas with mandatory steps, the mandatory mediation step prior to commencing arbitration could be given as an example. This was introduced in Italy, and it caused a significant decrease in the number of court cases and prompted the country's lawyers to go on strike. Now, another question that you must ask yourself is, what are the costs involved? Because both in litigation and arbitration, the cost can at times be very high. Another question, of course, is, what is the value of your recoverable damages? And whether or not this value justifies the costs that you will bear. Again, where do you intend to enforce your potential awards? This is quite important as the enforcement of a judgment given by a national court is usually subject to lengthy recognition and enforcement proceedings. In addition, there is a risk that these judgments will not be enforced even after the completion of such proceedings. Now, an example would be the relationship between Germany and China. To date, not a single German national court decision has been enforced in China. And additional considerations, of course, with respect to enforcement must be given with respect to litigation, particularly with bilateral or multilateral agreements between parties. Again, another question of quite a big importance is whether or not you intend to keep your disputes and sensitive information private and confidential from the press and the general public, as litigation is a procedure that is generally not open to the public. Do you seek flexibility, or do you need informality in your dispute resolution form is another question, as this is generally not available in litigation. And finally, and I believe it is one of the most important questions that you must ask yourself, is whether or not fairness or neutrality is a factor that you have to consider. And this would usually be an issue to consider when you may be a litigant in a country where the disputing party operates in or resides in. So with respect to the use of international commercial arbitration, there have been extensive studies, but the general consensus is that when you're dealing with a corporation, maybe a global or a local corporation, which contracts with parties from all over the world, which basically is constantly building transnational cross-border relationships, and which deals with dealings in a particular sector or anticipate disputes with a technical and complex nature, arbitration is generally preferred over litigation. Now, just going into arbitration and what that means, arbitration is generally defined as a consensual, private adversarial process based on the mutual agreements of the contracting parties. It is considered an alternative route for dispute resolution, but there is, of course, debate going on as to whether it is actually an alternative due to its wide use and whether that term should be used at all. But it is a system which is based wholly on the express mutual consent of the contracting parties. And this concept may be recorded in either an arbitration clause, which looks to the future, or a submission agreement, which looks to the past. And what I mean by this is basically the former, the arbitration clause, is established prior to the dispute. Usually when the parties are creating their contract, the contract is executed by and between them, whilst the latter, the submission agreement, is established by the parties after the dispute appeared. Now, it is a private system, so unlike litigation, the private nature of arbitration provides the contracting parties with the opportunity to form a customized dispute resolution administration system. Thereby, the parties are really able to create or form their own system and pick and choose what works for them. The whole system is administered by a sole arbitrator or a panel of arbitrators, which is called a tribunal. So what I mean by legal advice access with respect to arbitration is that you usually do require external counsel. And just because a legal counsel should be able to give you advice, not only on the procedure itself, but on the composition of the arbitral panel, whether or not to use rules from certain arbitral institutions, whether the arbitration should be administered by a named arbitration institution, the governing law, the seat of the arbitration, which basically means the system of law that governs the arbitration system, and the extent to which appeals to courts should be allowed. And the final thing to consider is arbitrability, because arbitration is at times unavailable, and this can happen due to two reasons. The first is that arbitrability really flows from the contractual basis of arbitration. You yourself choose as a party the types of dispute that may be submitted into arbitration. But the second is that arbitration may be unavailable due to the operation of the law. And there are very reasonable and valid policy reasons as to why a state may wish to subject certain disputes to public hearings before the courts. So some examples would be criminal conduct, prohibited transactions such as money laundering, loss of state revenue. But there are also matters where the subject of the dispute is within the exclusive jurisdiction of national courts, such as real estate transactions. Now, just looking into a few general principles of arbitration, we could start with the principle of party autonomy. Now, it may be defined as the party's right to choose and/or omit any procedural or substantive law within certain parameters and exceptions, and these could include things such as public policy, mandatory rules concerning public interest, or the party's due process rights. Now, according to this widely accepted principle, parties are able to retain control over the procedures adopted during the administration of the arbitration process, which basically means that these parties are able to achieve a desired speed and/or flexibility depending on the demands of their business practices. So it's very business friendly. The procedure may align with the aims of the parties. So what I would like to say about the responsibility to make fundamental decisions is this. Parties are actually responsible to make fundamental decisions so that their agreement is valid. And these things include such as the seat of the arbitration, the scope and ranges of the disputes that are subject to arbitration proceedings, and the languages of the arbitration proceedings. Additionally, the parties may choose to incorporate the rules of particular arbitral institutions, and they may be generalist or specialized institutions. Some examples of generalist arbitration institutions would be the International Chamber of Commerce, the American Arbitration Association, the Singapore Arbitration Center, and the Istanbul Arbitration Center. Specialized institutions would include examples such as the International Center for Energy Arbitration, Shanghai Aviation International Court of Arbitration, or the panel of recognized international market experts in finance. Now, of course, the parties may also choose ad hoc arbitration, where the parties are responsible for determining and agreeing on their own arbitration procedures, rather than being supervised by procedures of an arbitral institution. And finally, just going down to right to consider and adopt secondary procedures. So beyond everything that we spoke about, the parties also possess the power to decide on matters such as the scope of their evidentiary disclosure, the arbitration selection procedure, the time frame of the performance and completion of the arbitration. Moreover, depending on the needs, the contracting parties may adopt expedited procedures to speed up their resolution process. They may adopt procedures whereby the parties are required to refer their disputes to mediation prior to or alongside arbitration in an attempt to reach a solution. Or they may decide to dispense with the oral hearing due to costs. Now, looking into the principle of separability, it may be defined as this. The arbitration clause in a contract is considered to be completely separate from the substantive, the primary contract of which it forms a part of. And as such, it survives the termination of that contract. So when examining the fate of an arbitration clause in situations where the main agreement is held to be void or voidable, it is generally recognized that the arbitration clause is separable and severable from the whole agreement. This basically means it just survives even if the main agreement in question is ill-fated. Now, there is very strong public policy in favor of upholding arbitration agreements in a contract as separable and severable from the rest of the substantive contract. And when we look into its functions, this approach is quite vital to preserve the parties' entitlement to arbitration and generally trumps the rule whereby null, void, or voidable agreements produce no legal effect in their entirety. And obviously, it would be quite self-defeating if a breach of contract or a claim that a contract was voidable were sufficient to terminate the arbitration clause as well. This is a situation where arbitration clause is most needed. And another approach that we can take is, in fact, there are two separate contracts between the parties. So one would be the primary, the main contract, which concerns their commercial obligations. But the other, the secondary, collateral contract, contains their obligations to resolve any disputes arising from their commercial relationship by arbitration. So in any event, any dispute arises from the primary contract, the secondary contract will form the basis for the appointment of an arbitral tribunal and for the resolution of the dispute. Now, this obviously is quite widely recognized, and of course in France, the United States of America, and China are examples of countries that recognize this doctrine. As widely accepted as it is, one must be careful with respect to the separability issue, as there are states that has not yet accepted this concept. And an example would be the Estonian Supreme Court. In 2004, it has ordered that a null and void arbitration agreement may violate or ignore Estonian policy. Apologies, I was just informed that my voice wasn't really well, and I hope you can hear me better now. Could you guys let me know if you can hear me right now? Okay, well, I haven't had any comments, but I assume it is fine, so I'll just go on. So I was just saying we were at the Estonian Supreme Court. So yes, it has held that a null or void arbitration agreements may violate or ignore Estonian public policy. Now, just going on to the selection of impartial arbitrators. So the contracting parties may appoint a sole arbitrator or a panel of arbitrators, or may form a procedure whereby the arbitrators are appointed by their desired institution. And so what I mean by complex or technical disputes is basically choosing the arbitrator is of particular importance when the nature of their respective business and dispute is complex and or technical. Again, what I mean by sector-focused resolution is that the right to choose the arbitrator is invaluable when an arbitrator possesses the professional qualification, experience, insider knowledge, and know-how in a particular business area, and or the types of disputes that may appear within the respective sector. Now, when we look at improved management or decreased dependency on experts, the choice of an experienced arbitrator who is familiar with the resolution of complex disputes arising from international business relations may result in the parties attaining a decision in a swifter manner. But it may also lessen the parties' dependency on experts generally. And finally, contracting parties have a wide variety of choices for arbitrators and may utilize the services of specialized institutions and associations such as the Panel of Arbitrators for Intellectual Property, the Society of Construction Arbitrators, and London Maritime Arbitrators Association. Now, looking at the mandate of the arbitral tribunal, so the jurisdiction and powers given to an arbitral tribunal really depends on the mandate given to it by the parties. So in other words, an arbitral tribunal will not have jurisdiction, it will not have any powers unless the dispute comes within the terms of the particular reference to arbitration within either their arbitration clause or submission agreement. And what this all means is that arbitrators cannot make decisions against a person who is not a party to their agreement, which of course may be very unfavorable for some types of disputes. Or these tribunals are unable to make a decision on matters that are not covered by your agreement. Likewise, the tribunal is only authorized to determine a dispute actually referred to it and on terms of the agreement between arbitrators and the parties. So I would just like to go into how parties are conferred on tribunals. The parties may directly or indirectly confer powers upon the arbitral tribunal. And direct conferment of powers takes place when the parties agree expressly upon the powers that they wish the arbitrators to exercise in their agreement. Whereas indirect conferment of powers takes place when the parties have agreed that the arbitration is to be conducted according to pre-established rules of arbitration that set out the powers of the tribunal. And finally, there is an additional source of power for the tribunal, and this is the operation of the law of which the law governing the arbitration agreement itself or the law governing the arbitration. So the tribunals may be supplemented with powers in addition to the ones that were given to it by the parties, but also the powers given to them by the parties may be restricted by virtue of the operation of the law. So an example would be where the English Arbitration Act gives the tribunals the right to order a claimant to provide a security for costs, or the power to administer oaths to witnesses. However, in the end of the day, this constraint doesn't necessarily mean that the arbitrator is prevented from making a decision concerning a matter that arises after their appointment. Now, another thing that we must look into is privacy and confidentiality, and obviously this is another deciding factor on the method of a dispute resolution procedure. Therefore, a business entity, a party that would like to keep its sensitive information and disputes private from the press and the general public, may consider arbitration as a confidential forum that would achieve a level of confidentiality concerning the subject matter of the dispute and the information submitted to the arbitrators. And a distinction has to be made between privacy and confidentiality. Privacy basically means that it is a private process, whereas confidentiality is an obligation. It's a duty on the arbitrators and on the parties of arbitration not to give out information relating to the content of the proceedings. These include matters such as evidence, documents, expert reports, addresses, transcripts of the hearing, or the awards. And again, it is very important to note that confidentiality and privacy does not really automatically exist just because you chose arbitration as your dispute resolution forum. So confidentiality is based on the fact that the parties have agreed to submit their dispute to arbitration between themselves and only between themselves. The current trend is that a wide-ranging confidentiality duty cannot be implied. Now, this is the position that prevails in Sweden and Norway. And obviously that means that you must agree in your agreement that these procedures are to be held confidential. But do not forget, matters such as public policy may restrict your agreement on confidentiality to the extent necessary. Likewise, privacy is based on the fact that arbitral hearings are held in private, and the press and the public are not entitled to attend such hearings. Now, going for enforcement. So, in principle, the enforcement of an arbitration award is generally simple, as we might all know, by virtue of the Convention on Recognition and Enforcement of Foreign Arbitral Awards, which is also known as the New York Convention 1958. Whilst the enforcement of judgments handed down by national courts are usually subject to complex procedures based on national legislative systems. But there is a risk, and there is a risk of regional protectionism, whereby certain courts at times can refuse to enforce arbitral awards, even if their country is a signatory of the New York Convention. And now, before getting into a different topic, I would like to mention three matters. One, and very briefly, one is that there is no appeal process for a final award in arbitration, save for annulment proceedings or judicial review applications to national courts under very restricted circumstances. Two, you are forced to take all legal recourse issues through an arbitration hearing. And three, arbitration can be very costly. Now, as I had previously mentioned, there has been extensive studies with respect to the use of arbitration as a dispute resolution forum. Now, these studies are quite important as they demonstrate the view of corporations and their outlook on arbitration. And there were two studies that really caught my eye, and I would like to go through them with you. So the first one is the 2013 International Arbitration Survey on Corporate Choices in International Arbitration. It was prepared and released by Queen Mary University and PwC. So just going over the key findings together. One, it says, businesses continue to show a preference for using arbitration over litigation for transnational disputes, although concerns remained about the cost of arbitration. Two, the survey confirmed that arbitration is more popular in some industry sectors than others, most notably in energy and construction. And three, while most financial services sector organizations prefer litigation to arbitration, the benefits of arbitration are increasingly recognized. Most corporations in this industry agree, in principle, that arbitration is well suited to the resolution of their disputes in that sector. So although this is a 2013 study, it provides a unique insight into the evolving processes surrounding arbitration, user preferences, and perceptions. Now, of course, there was also another study that was held in the year of 2018, which showed drastic changes in user preferences. So just looking into that survey, this was also, again, held by Queen Mary University with White & Case Law Firm, which is titled the International Arbitration Survey on the Evolution of International Arbitration. So if we look into the key findings again, 97% of respondents indicate that international arbitration is their preferred method of dispute resolution, either on a standalone basis or in conjunction with alternative dispute resolutions. The second is enforceability awards continue to be perceived as the arbitration's most valuable characteristic, followed by avoiding specific legal systems and national courts, flexibility, and the ability of the parties to select arbitrators. Third, cost continues to be seen as arbitration's worst feature, followed by a lack of effective sanctions during the arbitral process, lack of power in relation to third parties, and lack of speed. And I think most importantly is the fourth finding, which is an overwhelming 99% of respondents would recommend international arbitration to resolve cross-border disputes in the future. So it could even be argued that arbitration is an alternative, but the usual method to resolve commercial disputes. Now, just going into the impacts of the COVID-19 outbreak, and as we're all aware, almost all governments around the globe try to contain the virus and reduce contact among members of the public through very aggressive measures, such as closure of borders, quarantining of international passengers, declaration of emergencies, lockdowns of countries. So what is the impact on the courts of law? And in line with the measures that we just spoke about, we are really able to see a significant disruptions to dispute resolution forums, particularly with regards to courts. And may they be international, regional, ad hoc, national courts of law tribunals. So I just want to give you a few examples. So one would be the International Court of Justice and International Court. It is known to be the principal organ of the United Nations. It has suspended all meetings and hearings until the 31st of May 2020. Let's look at a regional court, which is the Court of Justice of the European Union alongside the General Court of the European Union. They again have temporarily changed their working arrangements and are prioritizing particularly urgent matters such as urgent proceedings, expedited proceedings, and interim proceedings. Looking at Republic of Turkey, the most prominent and the biggest courthouse is the Istanbul courthouse. It restricted its activities as of the 6th of April 2020. Again, in France, courts were closed as of the 16th of March 2020, with the exception of essential dispute resolution. In Germany, the German Federal Administrative Court restricted its activities as of the 18th of March 2020, with exceptions of matters that could not be postponed, and started its operations on the 19th of 2020. The United Kingdom was brilliant in enacting the Coronavirus Act 2020 as a temporary emergency legislation, and adopted additional practice directives 51Y, 51Z, and 51ZA. Likewise, no jury trials are underway. Family courts and civil courts are listing priorities on a daily basis. The High Court and the Appeal Court are only covering urgent works. Looking at Italy, the Supreme Court of Italy was initially closed, but they began dealing with only urgent matters. Hong Kong, at the same time, announced and extended a general adjourned period, a gap period, which means that all court and tribunal hearings were postponed during this period unless they were deemed as essential business. And finally, looking at India, the Supreme Court, the Bombay High Court, the Delhi High Court only hear urgent cases. And last but not least, Japan, following the declaration of the state of emergency, some courts have temporarily listed the scope of their services. So really these examples show the impacts of the virus, which it has had on the course of law, and that the virus did not discriminate. And these impacts really derive from the fact that these courts work in certain buildings allocated to their workings, and the fact that they require person-to-person contact while conducting their official business. So I thought, let's look into some random arbitral institutions to see what type of impacts the COVID-19 has had on them. So let's start with the International Court of Arbitration of the International Chamber of Commerce. So the ICC has announced all offices were open and operational, that they had special arrangements put in place and will likely remain in force for the immediate future. They also stated that you are able to lodge requests for arbitrations, applications for emergency arbitrators, and you may request additional ADR proceedings. Looking at the SEC, the Stockholm Chamber of Commerce, it has also announced that it is fully operational and that the infrastructure in place at the time of the outbreak supported a smooth transition to working remotely. They also stated that the SEC's case management has been fully digitalized and that their digital services was extended to parties, counsel, and arbitral tribunals. It is a very different picture when you look into the arbitral institutions. Another example, again, is JAMS. They've announced that they're open for business and their neutrals and staff have access to technologies for the continuation of their services and hearings. Again, the London Court of International Arbitration announced that they expected to remain open and confirmed that they expect requests for arbitrations and that their ongoing arbitrations are continuing in an uninterrupted manner. The WIPO Arbitration and Mediation Center very similarly has stated that they continue to receive and administer cases submitted to them, and that they also make available at no cost online case administration options, including online docketing and video conferencing facilities. Looking at Singapore International Arbitration Center, again, it is fully operational, and that they have also announced that they're prepared and well equipped for this transition. Looking at Dubai International Arbitration Center, very similar. They have announced that they accept submissions electronically, and you may submit your documents and your requests through their online portal and websites. They've also stated that hearings could be held either by video conference or could be postponed, subject to the decision of the sole arbitrator or the tribunal. And finally, Istanbul Arbitration Center very recently announced new rules for the conduct of hearings via video conferences. So really, apart from the control that is provided to the parties with arbitration, the beneficial and flexible nature of arbitration was really demonstrated during the COVID-19 outbreak. The real difference between litigation and arbitration can really be seen from these examples. Now, we're really able to see that the adaptable nature of arbitration has ensured that it can adapt to external factors such as this outbreak. Most arbitral institutions, as we've seen, are open and fully operational save for their oral hearings, and have adopted additional measures such as electronic filings or checklists for the uninterrupted continuation of ongoing arbitration cases. So therefore, the continuation of a case would not be disrupted unless the parties agreed that a hearing should be adjourned so it could be held in person. And this also applies to ad hoc arbitration as well, where the parties are in complete control of their proceedings. However, on this subject, I think it is my duty to mention that online hearings should be approached with caution. Although possessing electronic mediums for the continuation of dispute resolution may seem beneficial at first, the decision to hold a hearing online requires a detailed analysis of the case itself. So although we are aware that hearings have been held previously online, there are concerns on the confidentiality of the mediums used, such as Zoom or Skype, and the effectiveness of such hearings. There are opinions that it would be very difficult to cross-examine witnesses and experts, that connection problems could cause disruptions to the hearings, and that overall online hearings could result in a party not being able to present its case in a fair and effective manner. However, others advocate the use of online hearings, particularly with respect to our current circumstances. But regardless, at least with arbitration, the parties of a dispute have the chance, the opportunity to consider whether or not they would like to continue with their hearing. And in contrast, and as mentioned previously, most courts of law have suspended or temporarily ceased their works, which will unquestionably lead to an unavoidable accumulation of work, disruptions, and delays. Additionally, although certain judicial authorities are able to benefit from electronic mediums in conducting their cases or handing down their judgments, obviously within very limited circumstances, if I might add, this is not a universal method utilized or available to all. There are also debates as to whether the judiciary is able to effectively use electronic mediums, even if it is available to them. So, in conclusion, and I really hope this information will assist you in evaluating your options with respect to your dispute resolution forums. It cannot really be said that one method is better than the other, but they do possess core differences that must be examined before a choice of forum is made on a case-by-case basis. In the event you would like to ask me any questions about the subject of this webinar, please do not hesitate to contact me through my email address, which you can find on the slides. And finally, before I log out, I would like to wish everyone who practices the Muslim faith a joyous and healthy month of Ramadan. And I wish you all an amazing day. Thank you very much for joining me today. Thank you.